Welcome to the Star Chamber. I'm Bruce Starr. I'm the state senator from Senate District 12, representing Yamhill and Polk counties. Today, we're going to talk about something that has potentially will add costs to every public project, about 20%, we think. That's project labor agreements. Something that most Oregonians don't know about, but the governor in December signed an executive order that mandates project labor agreements on virtually every public project in the state. We're having a conversation today with members of the Associated General Contractors. Mike Salsgiver, he's their president. I've known Mike a long time. Also, Kirsten Adams, who's their general counsel and primary lobbyist in the state capitol. And also Larry Gescher. Larry is a contractor. He owns HP Civil out of Almsville. I hope that this is a conversation that y'all find interesting and ultimately helps to shed a little bit of light on something that we're all kind of dealing with. And so look forward to this conversation. Thank you. Hey, good morning. Today we're going to talk about something that I think most Oregonians don't know anything about, and something that's driving up costs for infrastructure projects, roads that get built, bridges that get built, public buildings that get built. They drive up the costs by up to 20%. Project labor agreements, PLAs. With me this morning are three individuals with the Associated General Contractors, AGC, represent a wide range of construction clients that y'all represent. It's understandable, I think, that most Oregonians have no idea what PLAs are. Why would they? But we're going to dig into this subject a little bit this morning. So I think the first question that I'll pose to our guest this morning is, where were you the week before Christmas when you learned of an executive order that the governor issued on project labor agreements? So who's going to jump in first?
Kirsten got the call, so let's let her go.
Yeah, I'll start. So it was the week before Christmas, and so we had a busy week wrapping things up, and we were finally having a little bit of festivity in the office, and we were watching a Christmas movie, and then I get a call from the governor's office letting us know that this is headed that way, and that was the end of the festivities. So.
Yeah, it kind of ruined the Christmas spirit, I bet.
It did a bit, yes. Yes, yeah. It did.
Yeah, you think of Christmas, you think of nice warm blankets and fireplaces. This was a big, wet, cold blanket descended upon us.
Yeah. What about you, Larry?
I think I was actually on a horse, riding my horse at the time, and I just remember seeing it thinking, game on.
Game on.
Because we had already obviously had the suit going with the CWA,
right,
with ODOT, and so then this was just a continuation of that. So surprisingly, we didn't wait till we got the results of that before we jumped into another one, but...
Well, yeah, I think I know that the governor kind of sprung that on everyone. I know she didn't talk to any legislator, from my understanding. Didn't talk to any of the presiding officers. Didn't talk to any interest groups, except potentially the one that mostly benefits from the project labor agreements. Before we kind of dig into this issue, I'd like each of you just to give a thumbnail introduction, introduce yourself, so our listeners this morning know who they're listening to. You want to start, Mike?
Sure. Thank you, Senator. Mike Salsgiver. I'm the Chief Executive Officer of the Associated General Contractors Oregon-Columbia chapter. Been there a little over 17 years.
Yeah.
Larry Gescher. I'm the president of HP Civil, heavy highway contractor located in Almsville. So I kind of got introduced to the PLAs on the Selwood Bridge. I was working for Slayton Construction at the time, CMGC project. We were selected as a contractor, and then once we were selected, I started getting contacted by Ted Odlin, who obviously used to have a company called F.E. Ward. He had retired, and at the time he was working for David Evans. They'd set up a project management firm there with David Evans, Odlin Evans, and wanted to get together with me for breakfast on a Saturday morning. And it's like, what's up? And he goes, oh, I'll tell you when I get there. And so he told me that at the time, the chair of Multnomah County had promised the unions that job is going to be built by union contractors. And so then he found out they'd actually selected an open shop contractor, so it was a problem. So we went through about probably a 10-week period of time.
10 weeks.
Where you held our contract. Initially, he wanted me to meet with the unions. I said, well, I'll meet with the unions. And so it was actually I guess, an emboldened process for us, because at the time we weren't told we had to sign a PLA. We were asked to go meet with the unions, which we did. And so right away they started pitching PLA. We were teamed up with Sunt Construction out of Arizona, who's obviously a lot bigger firm and had been around the PLA stuff more than myself. And so we said, we're not interested in PLAs, and we have the guys to build the job that we've been selected to do. And then it got more and more robust as far as the conversation. To ultimately, it was like, I actually talked to the chair, and he told me they'd went through Clackamas County and was trying to get a licensing tax on the autos to help pay for the project. And so so the person that was heading up the campaigns called freaking out because the union said they wouldn't put any money into the project.
Wow. And
so then she called me, wanted us to make a donation. So we ended up making a donation for that campaign, even though you knew it was a loser. So then after they lost, then it ultimately came down. I started pushing for our contract because we'd pretty much done everything the chair had asked us to do. And so I called him, and he picked up his cell phone, and I said, looking for a contract. What's going on? I've done everything you've asked me to do. Oh, I don't know what's going on. I said, Jeff, I know what's going on. Your staff has told me, sitting on your desk waiting for you to sign it. So then, I'll check into it. And he hangs up. So then I immediately get a call back saying he's going to cancel the contract if we don't sign a PLA. And blame it on lack of funds. Wow. So then it became a different topic going to the table with the unions. Luckily, they didn't get that memo. So we actually had some power going in negotiations, which is a lot different than this PLA situation that was proposed here, because we'd be obviously sitting and waiting for them to tell us what they were doing.
Sure.
And so we were able to actually negotiate a 50-50 agreement on that one, which made sense. I mean, if you think about what a union's supposed to do, take the labor piece away from the general contractor's worries, and they take care of the recruiting, the training, and we find the work for them. Yeah. Obviously, it's broken. They're not doing that now. And so that's why we're sitting here.
Yeah. Kirsten, tell us a little bit about yourself and your role in this whole process.
Sure. So I'm the Public Affairs Director and Counsel for AGC, and been with AGC about 10 years. PLAs kind of started to come on the scene for us really heavily, probably about 4 or 5 years ago. And before that, I was probably like most listeners, not knowing much about PLAs, but we've had to become experts pretty quickly on the issue. And, it's with a legal background, it's interesting to look at it from, the statutory context too, and what we're supposed to be doing as a state in public contracting, and what we end up doing instead when we put a PLA on things. Yeah.
Mike, you want to give the reader kind of the listener, give us a primer on really what is a project labor agreement?
Sure.
What is it that we're talking about this
what
morning?
are these things? So in the business labor world, there are collective bargaining agreements, right? And so most of the time, those are negotiated between individuals representing a particular set of companies or interests directly with one of the trades. And so, excuse me. So let's use the carpenters, for example. There's a bargaining team that will get together, and they'll negotiate work conditions and other issues and health and welfare contributions. And then, of course, the big one is economics, the pay scales. And those come forward in a multi-year agreement, usually 3 to 5 years, somewhere like that. And those are contractors. In our case, they're contractors that have chosen to be union businesses, to hire from union halls, to employ union labor, and all of the rest. A project labor agreement is a mini version of that. So say when I was at Intel, we had PLAs that we did because we were very complex, schedule constrained, extremely expensive projects. And you didn't want anything to interrupt that. And so we would have basically the equivalent of a tiny bargaining agreement on a project. And so it is literally a project labor agreement. And that's what they are. Yeah.
So you can be pro-union without having, a PLA as it relates to a project. There's union shops, there's non-union shops.
Yeah, let's start with a profile of the businesses, and Larry and Kirsten jump in here wherever I miss something. But when you look at Oregon is a small business state, right? So 85% of the businesses in this state are very small companies. Same thing in construction. About 60 years ago, you saw the ratio of open and union start to invert. Used to be that union companies were the majority. And then as open shop companies started to make their own business decisions, you saw that ratio change. And so most of the companies in Oregon are non-union, about 86% of them, in fact.
Wow.
Same thing with construction. And so when I look at my membership, one of the things that we do is we have to protect that competitive environment. We represent all parts of the industry, so we don't really take a stand. We don't really favor one over the other. But when government puts its thumb on the scale and begins to take actions that interrupt our public contracting laws, which provide for fair and open competition and have for over a century, we will protect that. And we've done it on the other side too. Back in the early 90s, there was an executive order at the federal level that tried to bar project labor agreements. We don't like that either. If they want to voluntarily enter into it, that's good. But our job is to keep the playing field level.
Yeah. So that day in December, the governor signed an executive order. Kirsten, tell us exactly what that executive order said, and ultimately what it means to public projects in the state. And we're not just talking about, roads and bridges, but we're also talking about other public infrastructure, buildings, and whatnot. But give us kind of that sense of what that executive order meant.
Right. So it requires project labor agreements on all state projects or projects with state funds that obligated. So there's still some question as to what exactly that means, what projects might be contained in that portion of the EO. What was interesting about this executive order as opposed to other ones we've seen, including the Biden executive order and ones we've seen in other states, is that this doesn't have a threshold for project size. A lot of other ones, like Hawaii, for example, recently had an EO and it had, I believe, $1 million threshold. The threshold in Oregon instead is based on labor. So it's a 15% labor threshold, which any contractor will tell you is almost every project. So instead of having some kind of threshold for larger projects, it really includes everything. And so, ODOT is a big place that we think about this, particularly as we're talking about our transportation package.
Right.
But it really applies to any state agency that's looking to build anything. And so you look at the scope of this, it's pretty broad and impacting a lot of projects, a lot of contractors.
So PLAs require a union, basically union labor on a project. And Mike, you just said 86% of the contractors in the state are non-union.
Non-union.
So the governor, with the stroke of a pen, said, hey, 86% of the contracting community out there.
You have a choice. Basically, if you want to compete for publicly funded work in this state, you will have to agree to enter into one of these agreements, which 86% of them have already said,
that's not our business model.
That's not our business model. And not only the business owner has said that, but the employees have said that. And that's one of the issues I have, is you've just told 100 and some thousand employees, your views don't matter.
But we already have laws regarding public contracting. We have laws related to prevailing wage on public contracts. And those really are laws that protect union members, really protect the worker. So this particular executive order, what is it ultimately going to mean to, public projects that are out there, roads and bridges that get.
I'll use an analogy that I think most people understand. As an open shop contractor, we cross-train all of our workforce. So we may have a carpenter that's building forms for concrete one day, but he can go jump in an excavator and run an excavator. And, he can do every aspect of that job. So I'll use an analogy of a farmer. So you have a farmer, so he's building fence. One of the things that, a farmer may do is build fence. Okay, so he built a fence. Well, then his well goes down. Well, in the analogy of a union, that means that guy that's building the fence would leave, and now a plumber would come in to go work on his well. So then he's done working on his well, and he needs to go work up his field, get ready for a hay crop. So now the plumber leaves, and now an operator has to come in and drive the tractor. Well, he's done working up his field. Now his cow's going to have calves. So now you need a cattleman. So the guy that was driving the tractor leaves, and now a cattleman comes in. Well, our guys would do all those steps just like a farmer. One guy could do all 5 steps or 4 steps.
Right.
Or with a union, it's 5 different people. And so you lose the efficiency of your workforce because you have an operator. So operator sitting in a crane. Well, there's no crane work. So what's that guy do? He either goes home or he sits in the seat and does nothing versus getting off and going to help. They could get off and go help, but they don't because that's not my job description. I'm not going to do that. So there's some union guys that will do that. So some firms get their guys trained to where, okay, they realize they want to stay busy.
Right.
They don't want to get laid off when their job slows down. So they're willing to do other things. A lot of them, especially you get into your bigger companies, your bigger jobs, they won't cross the lines of their craft. And so that's the hard part. The unions have tried to compete against us doing that because obviously we're more efficient. They call it composite crew. And so a composite crew more or less allows them to have individuals that work out a craft, but they're paid the same wage. Well, if our guys work in a different craft, they get paid in a different craft. So that's a big piece of our business is keeping track of what that employee is doing every minute of the day, and he's paid accordingly. So if he's somebody that's starting out as a laborer and he's doing labor work, digging a ditch, whatever, well, that work's done. But if he picks up a hammer and starts driving a nail, he's now a carpenter. Even though he may not be fully trained into it, we're paying him as a carpenter, where that's where the union and the open shop are different. And so they obviously have the composite crew piece going, trying to get there, but it just doesn't make sense for, especially you get into any kind of smaller type projects, bigger projects where you have all this carpenter work to do, you have all this operating work to do, where those guys can get there and stay in their craft and keep going. It's easy to do that.
Right.
Small jobs where you have 3-4 man crew, it doesn't work because typically you're going to have an operator, a couple carpenters, and a laborer. That laborer gets drug into a carpenter almost all the time because he can't do anything as a laborer. The unions have pushed so hard on what that laborer can do that he can't stay busy. So therefore he gets upgraded to a carpenter because he's working with the crew. So we used to have material handlers,
Right.
and the union still does. But man, if we have a material handler, he better do nothing but, pack material. Otherwise they're coming after us through bully. They weaponize bully. If we don't dot our I's, cross our T's, next thing you know, you got bully coming after you. It's gotten a lot better than it used to be. Back in the OTIA days, you were around in the OTIA money phase.
Right.
And we see the pattern of when the unions get aggressive against open shop. It's when there's lack of funds or there's a whole bunch of funds. They get really active during those 2 periods because they're trying to either retain all the work and get more of it, or they're trying to get work that they don't have.
Right.
And so you kind of learn the nuances of the system, but that's really the big difference is how they operate. They just operate totally different between the two.
Mike, do we have an idea of what the additional cost this will generate in these projects? Do we have any idea? Is that study been done or?
Oh, yes. In fact, our very own Oregon Department of Transportation has done such a study.
Yeah.
And their conclusion is it can add anywhere between 10 and 30% to the cost of a project. Governor Newsom of California just vetoed a bill last September in California that would have mandated project labor agreements on state projects there because of the cost concerns.
Yeah.
And we saw on the Newburgh-Dundee bypass project, which was a legislatively mandated PLA project, that had one bidder, and it came in 22% over its budgeted amount. So these do have real effects, and we see it all over the country. There are numerous studies that substantiate that, and they're not necessarily by an advocacy group. They're pretty neutral studies, but that's the result. Yeah,
and that Newburgh-Dundee project, it took I think about a year just to negotiate that PLA. So
it did.
And time is money in construction. I mean,
got it.
we know that the longer it takes to get something done, costs continue to escalate.
Well, particularly in the post-pandemic environment, we're still feeling the effects of that. And so supply chain impacts have led to shortages in certain areas, have led to cost increases, have led to delays in process. All of that adds to cost.
Yeah.
And I'd say one other piece, a lot of times when folks talk about costs and PLAs, they also talk about, there's a talking point about increased wages for employees. And that really is just not accurate. All these projects are already prevailing wage jobs.
Right.
So everyone is making that amount regardless. And so the idea that, these projects are more expensive because folks are making more money and that it's going to the workers is just not accurate. It's a lack of competition. It's other pieces that add to that cost, but it doesn't really have any impact on people getting paid more.
There's actually, on prevailing wage, you have a base wage and a fringe. And so the employee takes home the base wage. The fringe is there to pay for their health care, their retirement, training, time off. And so as an example, I've chased this through a little bit just to educate myself kind of what the union dues actually cost. And so I took an operator, got the operator agreement, compared it to our operators, same group as far as operators, and chased it through. And so after we took out the health care, the retirement, the training, and any time off, there was $8 an hour left in the fringe benefit piece.
Wow.
That goes back to our employees and their base wage. On the union side, that goes into the union coffer. $8 an hour. And so you start adding that up, so that's why we're here. That's why they're pushing PLAs. Mm-hmm. It's for them. It's not for the employee. The employee takes home less money as a union employee than they do as an open shop employee working on public works.
Well, and one other part of that too is that when you look at an average project length, 2-3 years, those employees are never going to vest for those programs. So we're putting money into programs that the employees will never benefit from.
Wow. That's interesting. So is there a federal component to this conversation?
Oh, yes. Yeah.
What does that look like?
Well, it's very similar, actually. In fact, Oregon is kind of, in our internal conversations, I call it the mini-me version of it, because you're seeing right now the federal courts, the federal claims court, for example, just a few months ago in February ruled that PLAs are illegal, and they ordered them to back them out of federal contracts. You're starting to see that happening. The Trump administration is getting its arms around what its policies will be, but it looks like they're heading toward limiting or requiring them to be withdrawn or seriously diminished. There's a law, the Competition and Construction Act, CICA, and that's the basis of the federal claims court ruling that happened in February. That applies to federal projects here. So anything that has a federal nexus of funding it's going to impact it here as well.
Yeah. So the governor signed the executive order. Everyone was caught by surprise. What did AGC do after that?
We met with her. We met with her in January on a Zoom call. She was cordial, and listened to us.
And her is the governor.
We met with the governor, right. And it was a cordial call. We asked her a couple of things. Please suspend or, first of all, bring us into the conversation,
right?
Which was a real problem with the ODOT situation, and that pattern continued. She rejected that. I asked her point blank, I said, Governor, you think of the building you live in, Mahonia Hall, in construction, that has a place in our history because of what it meant back in 1990 on reforming workers' comp.
Right.
Maybe there's an opportunity for a Mahonia Hall conversation on these labor issues. And could you convene us to kind of come out with a framework of agreement that we might be able to work from? She rejected that. She made it clear she was not happy with us on the ODOT lawsuit, and then that was that. We were pretty clear from there that there was not going to be a change, and so we had some internal deliberations and decided to bring legal action.
So you're suing
the governor.
Suing the governor.
Not a place you want to be.
No. So where is that in process right now?
Kirsten, you're the lawyer. You want to do it?
Sure. So as part of our lawsuit, we were getting close on the deadline for when projects would all have to have these mandated PLAs on them. And so in addition to filing our lawsuit challenging it, we also filed a request for an injunction, and we were granted that about 2 or 3 weeks ago here in Marion County. So that means that they can't put these mandated PLAs on any projects until the circuit court makes their decision. So it gives some time for for the court to make their deliberations and determine whether or not the governor had the authority to do what she did with the executive order.
So you're claiming that she went beyond her authority as the executive in the state of Oregon, basically became a governor /legislator and legislated when she didn't have the authority to do that.
Yeah, we don't have a govelator here, so that was the basis of it.
Yep.
And so, is that in Marion County Court?
Marion County, yep.
Marion
Which is
County
also where we had, so we've mentioned a couple of times the ODOT issue. And so there was a lawsuit started about 2 or 3 years ago against ODOT for a CWA, which is it's a community workforce agreement. So it has PLA aspects to it, and they were putting it on 8 pilot projects. And so we challenged that, and we're just this last week, we're successful at the Supreme Court level to get that knocked down as well.
That.
Yeah.
Yeah, there's some good law that's starting to emerge as a result of this, but it's going to take additional work to get further clarity.
Is there, I guess the courts kind of abide by their own timeline. There's not like the legislature's gonna sine die and we have a deadline. The court process, there is no such thing, right? It kind of takes as long as it takes.
Right, which is why we went for the injunctive relief, because that has to be done on a pretty quick timeline. The idea being that there will be harm done if there's not relief granted. And so with that, once we have that piece done, we are at the mercy of the court's timeline.
And Kirsten, you've been in the legislative bill process for a number of sessions now. It's not as if project labor agreements haven't been a topic of conversation in the legislature, correct? I mean, that is something that has been debated and discussed, and bills have been introduced, and yet the legislative branch has, basically due to the lack of action, has already weighed in on this issue.
Exactly.
Knock on wood.
Yeah, right.
Yeah, we're still in session. So.
Right.
But yeah, in the 2023 session, probably was the biggest example. Senate Bill 850 would have put PLAs on most state project or public projects throughout Oregon. And so we fought that really hard with a very broad coalition from housing folks to we had the minority contractor associations, local governments. We had a pretty broad coalition, and that bill didn't make it out of committee. So it kind of goes to show you that, the legislature has had an opportunity to take action. There have been bills that pass that have PLAs as a component, but we haven't had a bill that has the breadth of the EO that's made it through the legislative process.
Right.
Yeah, and so for folks that are listening, I mean, we do have a process whereby laws can be changed, statutes can be changed, issues can be brought in front of the legislature. We've got 3 branches of government for a reason, and the legislative branch is the branch wherein statutes and laws get debated and discussed and amended and or not, and that's the system that we have. And in this case, the governor clearly went around that system.
Right. And when we have that system, it's an open system where we all have an opportunity, and all Oregonians have an opportunity to come and talk to committees and explain what their concerns are and talk to their legislators. And that's why when you have an opportunity to talk about a PLA, it gives an opportunity for the minority contractor community. It gives an opportunity for housing advocates to all come and talk about what this is going to mean. And when you have an executive order, there's just not that same engagement opportunity.
So you brought up the minority contractor community. Talk for a minute about how this executive order maybe affects them differently than, say, other contractors.
Yeah, so we've worked really closely with Latino Built and NAMAC. They both stand strong with us in opposition to the EO, and a lot of it has to do with our membership has much higher concentration of open shop contractors. Theirs is even more so. And so for them, it's similar to our membership of it really cuts out their ability to bid on these projects. And it's particularly difficult because there's so many things that legislatively the legislature tries to do to help minority contractors and help them build their business. And then you have something like this come along that's going to cut out their ability to bid and to compete on these projects. So in a lot of ways, very similar to our concerns, but even more so given their membership is more open shop.
Yeah. So huge impact on minority contractors in this state.
And that's been one of the frustrating parts of this process is when you go back to the ODOT situation, contractors were summarily excluded from the conversation. We were actually told you're not invited. Minority contractors, the advocates for those policies, were trying to speak for them. And yet when we would advocate and when they would ask to be at the table, they were not invited.
Yeah.
So that's frustrating.
It's any small business. I mean, if you're trying to start a company up, you have 10 employees and you have 4 different projects to send employees to, having craft specific people that are needed on that job, it's a constant shuffle. So it's almost impossible to get started and be efficient. I mean, you end up having to have too many people to fill all the roles that you need on that given day. So that's the downside to that PLA piece, is it really hamstrings you as a small firm.
Inefficient. That's what adds to the cost.
Yes.
And other things. Absolutely.
What I know that these project labor agreements, they're not simple. Why does it take so long to negotiate what these might look like what we saw in the Newburgh-Dundee effort?
If you go look at one of the PLAs out there, I mean, if I think about a union as an employer, it's the benefits of why I would want to join a union. So if the idea, I guess maybe I'll explain to them where they're going wrong and why people aren't joining unions. But as an employer, I would join a union when I don't have to worry about the labor force, because that's what I join a union for. So if I get a project and I need, 5 operators and 6 carpenters and 3 laborers, I can call the various craft halls and say, I need these people. And those people would show up. Those people would be well trained. Those people would be ready to go to work. They'd be drug screened, all those things. The problem is that you talk to any union person out there, they call the hall and ask for those people, and they're saying, we don't have anybody. Well, where does that leave a contractor that you have you're part of a signatory union for a reason, and that's why. And now you're told, well, you go find the employees. You go solicit, screen, and then send them to us and we'll sign them up. It's like, so what are you being paid to do then if you're not doing that aspect? And if you go look at the PLAs, they wrote right in the PLAs that every contractor has to put together a recruiting plan. Why would I be recruiting when the union's involved? That's what the whole purpose of a union is to recruit, train, and take care of the employees. So then general contractors have a path to put these people to work. And so that's one of the big things that's in the PLAs, is that recruitment piece that we need to do as a contractor. And so I look at that, it's like, it just makes no sense. I mean, if I have to do that work, why would I turn around then and send them to a union when I've already done the process and spent the money to go find the people? And so there's lots of things in the PLAs that I could see. I mean, obviously ODOT's probably slow at doing it because they get DOJ involved in everything they do like that. So you put that DOJ in the middle of it and start looking at all the different nuances that the unions want put in there. So obviously the unions know they don't have enough, their workforce isn't large enough to fulfill all these needs. So therefore we have to put an scapegoat in there. So they put it on the contractor to go find the employees to send them when they're short. And so that's why the union guys are against PLAs, because they're struggling to get good workforce now out of the trades.
Right.
So now all of a sudden, if you put all of us fighting for the small pool of people, we have a pool of people, craft people, but I would be surprised if half of our people would cross the line and say, I'm willing to sign up and go union, because most of them understand, or some of them have been there. We got a lot of people that are ex-union that work for us, and there's just different things they don't like about it and don't agree with. So they cross over and go the other way, and they're like, not doing it. I'll go find a new career because I'm going to be taking a pay cut. You got to remember, the PLA is only costing the employee. It's coming out of the employee's check when you sign a PLA. And so they're the ones that pay for it. It's not necessarily that as a GC, it's going to cost me on efficiencies. I'm going to have to look at things differently when I'm bidding because things are going to be slower, not as efficient. But the money's really coming from the employee to the unions.
Right.
And so they're the ones that ultimately really hurt out of the deal.
Right. Well, and we have to remember too, is when you're talking about public contracting, when you're talking about public contracts, ultimately it's taxpayer dollars that are being spent.
That's right.
And what it sounds like to me this morning that we're looking at, project costs that are going to increase. You mentioned between 10 and 30% more. So we're getting the same projects, and they're going to cost 10 to 30% more than they otherwise would, and potential delay as these PLAs get negotiated. You have to have a separate PLA for every project. Is that right? You need to
Under this order, that would be the requirement. You would have to have a separate project labor agreement for every state-funded project.
Yeah, so that's really efficient.
Imagine the buying power impact of that.
Yeah,
It's quite
so
stunning.
I really appreciate this conversation. I think that it's helped to educate me as a policymaker, and I think the folks that are listening to this. But look in your crystal ball, and I know it's impossible to predict, but what do you expect the outcome of your lawsuit will be?
Well, I think it's, my crystal ball is a little foggy this morning. I know what I'd like it to be. I think, it's a difficult policy, question that's being asked. And is, you have the, in addition to the public contracting question, you also have the authority questions. There's quite a few pieces kind of tied in. I think one thing we can be certain is that we will continue to see PLA pieces come through legislation, through local government. So regardless of what happens with the lawsuit, I think, this is something that we will be continuing to see and continuing to fight for years to come that's what I see in my crystal ball.
It's interesting, Senator. When you look at the two cases, the ODOT case and now the PLA, what we call the PLA-EO case,
right?
In both situations, there are procedural. The basis of the challenges are procedural. So on the ODOT case, it was they screwed up their rulemaking. In the case of the governor's order, we think she exceeded her authority as governor to issue an order like that. Interestingly, what's been interesting to me is when you go back and look at the ODOT ruling on the temporary restraining order or the injunction, Judge Gardner in Marion County issued a scathing statement the day she put her order in place. And she cut to the philosophical, the policy issues, as well as the procedural issues. Judge Hart on the PLA situation, on the executive order, did the same thing. So they acknowledge the procedural reasons, but those policy issues really have jumped out as, no, this is a fair and open. This is not fair. And it's not good policy to require something that doesn't allow true negotiation. It's not fair to create a situation where interested parties or affected parties are not brought to the table. And it's not good for Oregonians to put in place a policy where costs escalate that much. And the laws that we do have in place with respect to the public contracting process are summarily ignored. So I'm gratified by that, and I think we have an opportunity to prevail.
Yeah, and at the same time, the legislature is obviously in session, and clearly there's a large conversation about the Department of Transportation, the needs that they have in order to maintain current service level. And the opportunity that legislators are looking at, a transportation funding package, an increase in fuel tax and other fees in order to, continue to invest in our roads and bridges, the transportation system. And myself as somebody that's right in the middle of that conversation, not super excited about giving the department a bunch more money and then with an expectation that, 10 to 30% increased costs in projects makes it really difficult to go to Oregon taxpayers and say, hey, we're going to increase your fuel tax. And oh, by the way, all these projects are going to cost a lot more.
And then the Oregonian editorial board actually over the weekend had an editorial on the transportation package, and one of the pieces they brought up was the PLA mandate, and that the legislature shouldn't be putting more taxes until that mandate's no longer in place. So that's a pretty strong statement from the Oregonian editorial board about that it's exactly what you're saying. If we're going to be putting a lot of money into ODOT and putting that money, it's coming out of Oregonians' pockets.
Right.
Is this where we want it to be going?
Yeah.
One of the things that I'm grateful for is you're leading a management review of that agency. And while it's a somewhat separate issue, one of the practical effects of what we're seeing with this fiscal problem is that contractors are now, through delayed change orders, delayed or no payments, et cetera, are effectively picking up some of the cost of these projects. And I have a real problem with that. So when the opportunity comes to have that conversation, I'll be glad to do it.
Yeah, no, we're right in the middle of the legislature doing a relatively quick but deep dive on the management side of the department. We've retained a couple of individuals who are, from my perspective, know the right questions to ask. They've run either run large agencies and or delivered big projects, and they know how a department ought to operate. And so I'm looking forward to having the results of their deep dive, and then ultimately taking that information and from the legislative branch. It's a little bit of a challenge. It's not our job to run executive branch agencies, but at the same time, we are those that are responsible to our taxpayers, to our constituents, to ensure that the executive agencies are doing what they ought to be doing with the resources that Oregonians generously provide them. And so I'm, as a legislator, honestly proud of the legislative branch for doing this work and having the presiding officers, the Speaker and the Senate President, basically say, we've got to do this. And they were able and willing to put a few dollars together to make that happen. So hopefully good things come of that. So I appreciate this conversation this morning. I think that it's helped to educate this particular legislator and hopefully those that are listening. Any kind of final comment, thoughts this morning as we wrap this up?
I think for me, I think we will be successful on defeating the executive order. Unfortunately, I think there'll be another lawsuit eventually when ultimately we see PLAs get put on projects through the funding packages. As you've seen every time in session, they manage to always get something attached about workforce. It's like we have laws in place in Oregon already about workforce. We don't need it in a given funding package. The only reason we're doing that is try to pad the pockets of the unions. And so I think ultimately there's going to be a lawsuit involving those criteria that get put into, Newburgh-Dundee could have been challenged, I think, ultimately. So I think that's unfortunately going to have to happen in Oregon to finally put this to bed. We've seen it for, I can remember, I've been thinking about this for the last probably 16 years, going in testifying about PLAs. So obviously it's not going away anytime soon. So I think we're not done yet, but we're hopefully getting closer to making it come to a head.
Any final thoughts, Kirsten?
I just appreciate the conversation, the opportunity to talk particularly about how this impacts, to Larry's point, the employees, and how, how it impacts our fair and open competition that we're supposed to have in public contracting. And I think, as we use that as a lens, that's what we should be looking at on policy, is how do we make sure every Oregonian gets to compete on these projects. So I appreciate the conversation.
Mike, anything fun?
No, I would echo both Larry and Kirsten. I think we're in for a longer fight unless something comes along that stops these in their tracks. We're not anti-PLA. I want to be clear about that. We're anti-mandated PLA.
Yeah.
As far as the other side of it, though, the word I used a little bit ago was grateful. I am grateful to you and your colleagues for being willing to not only engage, but do your job as legislators to provide oversight to these agencies and to these issues, and then bring them forward so we can have intelligent conversation and make good law.
Competition works. Free markets generally work, and we need to encourage competition. We need to encourage that and not discourage it. And that's really, I think, the bottom line here is that this particular executive order basically, as you mentioned earlier, puts the thumb on one side of the scale, and it reduces competition. When you reduce competition, costs go up, and we need as much competition as we possibly can, so we get taxpayers what they need as we are really spending taxpayer money. So, thank you very much for the conversation this morning. I appreciate it.
Thank you.
Senator.
Good to see you.